Hello everyone, you're welcome again to Jaded Law Channel. This is a law channel where you have your legal needs met, questions answered, and issues resolved. In the last episode, we talked about the rights and the obligations of the tenant. We also mentioned that at some point, that the landlord may just feel dissatisfied and decide that the tenant, for one reason or the other, should vacate the premises. What should the tenant do? Does the tenant have the right to insist that he would continue staying in the property? The answer, of course, is no. And the reason for that is because the landlord also does not have the right to insist that the tenant must stay. So at whatever point that anyone feels dissatisfied, he or she is free to terminate the tenancy. However, the tenant has the right to receive the required length of statutory notices. What are these statutory notices? They are the quick notice and also the notice of owner's intention to apply to recover possession. This is what we commonly call the 7 days notice. Now, for one to be able to decipher what kind of notice should be served, it is important that we understand the different types of tenancies. So we have the monthly tenancies, the quarterly tenancies, half-yearly tenancies, and then we have the yearly tenancies. The monthly tenancies are such that the tenant pays rent monthly. Quarterly tenancies, on the other hand, are the tenancies in which the tenant pays his rent every 3 months. The half-yearly tenancies are such that the tenant pays his rent every 6 months, while the yearly tenancies are such that the tenant pays his rent once a year. Having said that, a monthly tenant is entitled to a 1-month notice. What I prefer and what I believe very strongly is the correct position is that it should be a clear month. What do I mean by this? I do not subscribe, and I have quite a lot of cases that buttress the point I'm making, that a tenancy should be determined in between months. What do I mean by this? Let's say, for instance, we are in the month of February and I want to give a monthly tenant a 1-month notice. What I prefer to do in giving a clear month notice is to ensure that even if I prepare the notice in February, since we're already maybe 22nd of February or whatever, the notice begins to run from the first day of March and ends at the last day of March. So I may serve this notice in February, but it will determine or terminate the monthly tenancy at the end of March. For a quarterly tenant, is entitled to a 3-month notice. Interestingly, a half-yearly tenant is also entitled to a 3-month notice. For a yearly tenant, he ought to be served with a 6-month notice. Now, having said that, you'll recall that in one of the episodes, we talked about the fact that sometimes the tenancy agreement may be in writing. The agreement may, for instance, where in writing, stipulate a shorter length of notice. And if that is the case, that is what becomes binding on the parties. So this is the length of notice, depending on the kind of tenancy that the tenant has, that should regulate the relationship between the landlord and the tenant. Now, some issues arise where some overzealous landlords, in concert with their lawyers, decide, oh, I'm just done with this tenant, he's got to get out of the property. And sometimes they may now decide to backdate a notice or give a shorter length of notice. What should the tenant do? I'm so sorry we will not be able to take that. In this episode, we'll be treating that in the next episode. You just stay and be glued to this channel and you will get to understand what to do in such a circumstance. Again, ignorance of the law is no excuse. I would urge you to subscribe to this channel, and if you like the content, Would also appreciate it if you can tap on the like button. Help us. Send in your comments and your suggestions so that we would know exactly how to have your legal needs met. Thank you so much and see you in the next episode. God bless you.